direct or even indirect way?
Well, the public domain that Tony recognizes is not the public domain that I recognize, and I don't want to diminish the importance of the public domain. It is the destination of every work, and it is rightly the destination of every work. I guess I missed all those cases that said that once in the public domain, always in the public domain. There's a whole page full of citations of the 10th Circuit decision from 1997 that says it's a bedrock principle of copyright law that once in the public domain, always in the public domain. And not a single one of those cases stood for that proposition. The public domain is simply the absence of copyright protection. That which is not protected by copyright is in the public domain. I'm aware of no case law that says that as a matter of constitutional law, that cannot change. This will be the first case that I know of to actually confront that issue, and we'll get an answer in a few months. And finally, limited times, as Justice Ginsburg said, limited times doesn't even come into play. Limited times is about when protection ends, but for these works, protection never began. So limited times is really beside the point.
I think I would disagree with that slightly. And the only thing I would disagree about with that is I think we both agree that Tony's wrong. We might slightly disagree on the reason. One reason is because I think if you're, the word public domain and the phrase public domain, especially as my friend has described it, is an extremely attractive abstraction. But that's all it is. It has nothing to do with reality. Works are in the public domains for different reasons, and the reasons that they are in the public domain depend on whether or that will determine whether or not Congress may yank it out. So, for example, ideas are in the public domain. That is one kind of public domain. That is a public domain created by the First Amendment. Congress can't yank ideas out. That's fine. Suppose Congress were to, suppose a work was in the public domain, e.g. unprotected, and Congress tried to pull it out and it didn't have a good reason or a rational reason for doing so. That work deserves to stay in the public domain. But there's another kind of public domain, and that is the kind of public domain that is actually at issue in this statute, which is where Congress has created a system of formalities to give, using its discretion, to give a work a term or not, or no term. And then later decides, again, for pretty good reasons, to revoke those formalities and to restore protection to that class of works that, in its view, unfairly forfeited protection and granted windfalls to other people. Those kinds of forfeitures Congress may constitutionally remedy, and that public domain is not one that Congress is constitutionally forbidden from effecting. That's how we see it.
So that's an interesting point, because the Solicitor General was pushed on this. That is, at the higher level of abstraction, the question is, even if for these reasons this particular class of authors deserves to